The Passamaquoddy Nation went to Augusta with some of the elders of the tribe to try and seek a way for redress of what he had thought were the lands improperly taken. An assistant attorney general informed him that if he should decide to take the case to court, he wished him luck. For a number of years, Indians from both the Passamaquoddies and Penobscots have searched for a way to do this. But Maine, like many states, has what is known as sovereign immunity. They may not be sued by an individual unless the state gives its permission. And Maine, of course, did not want to do that. There's an act which was passed by the United States Congress back in 1790 called the Non-Intercourse Act. It stems from a tradition which the old countries in Europe had had, that they could not just claim any land which they found if it was inhabited. Because the land was inhabited that they landed on in a, quote, New World, they claimed that they had the sole right to negotiate for the purchase of that land. When we became a United States of America, the Congress passed in 1790 a law very similar to that tradition, that the United States government had the sole right to negotiate and purchase land from the inhabitants. In 1972, a petition was filed with the Secretary of Interior of the United States asking the Secretary to file a claim against the state of Maine to claim the lands which were illegally taken. This was turned down. In June of 1972, a lawsuit was brought against the United States requesting four things. They requested the judge to decide that the 1790 law applied to the Passamaquoddy Indians. They requested that it be stated that a trust relationship existed between the United States and the Passamaquoddies. They requested that if such a judgment was found, that if the United States failed to pursue the claims which the Indians had claimed, that this would be declared illegal. And the fourth part of this, as a holding action, they requested that a suit be filed on behalf of the Penobscots and the Passamaquoddies for $150 million each, that if the judgment were found in favor of the Indians, that this could later be amended. In January of 1975, Judge Edward Janeau of the United States District Court agreed that all of the conditions that the Indians had requested were in fact true, and he instructed the federal government to file suit on behalf of the Indians. This decision was appealed. In December of 1975, the Circuit Court of Appeals unanimously upheld Judge Janeau's ruling. The procedure at that point was for the United States or the state of Maine to appeal this to the Supreme Court of the United States. They had a deadline to do that, and they did not meet the deadline. They decided by March of 1976 that they would not appeal the case. There are many questions and fears that have been raised by the publicity surrounding this case. The panel which we have today is a discussion of four individuals to take a look at some of the fears and discussions on the land claims case. The four panelists that we have today are James Mitchell, who is a practicing attorney and former director of the Maine State Housing Authority. Willard Walker was a professor of anthropology at Wesleyan University and has worked with a number of Passamaquoddy Indians over the past few years. Wayne Newell, who is a Passamaquoddy Indian and who is director of the Wabanaki Bilingual Education Project at Indian Township. And Robert Ruman, who is a professor of philosophy at Colby College. The moderatrix for this program will be Winifred McFedrin of Reedfield.
The issues that have surfaced because of this specific case are broad, much broader than the land claims case. And if addressed, they can help us understand past and current relationships of Maine and Maine Indians, and perhaps suggest what these relationships should be in the future. Rather than lectures from our scholars, we have asked them to respond to some of these fears, questions, concerns, and public statements that we hear with more and more frequency. in the state. The first question, Indian land claims are such old claims, how can they mean anything today? Doesn't Congress have the right to extinguish Aboriginal title?
Well, Congress may have the right to extinguish Aboriginal title, but they haven't done it in this case. And there's nothing really inherently bad or wrong or ineffective about an old law or an old piece of paper. We're dealing with a law that was passed in 1790. We live under a Constitution that was adopted in 1789. So the law is more recent than the Constitution, and no one would suggest that the Constitution's no good just because it's old. And we're not dealing with a claim that came up in 1790 and hasn't been heard of since. We had the law passed in 1790. A treaty was entered into in 1794, which took away a great deal of the land of the two Indian tribes, and probably in violation of this law. That's what the case is all about. Some people say, well, they waited from 1794 until now to raise the claim, but they didn't. In 1836, the state of Maine passed a resolve which would have allowed the state to sell all of Indian Township, all of the land which was reserved in the 1794 treaty. Then in 1854, the legislature, again, having thought better of its earlier law, passed another law allowing portions of Indian Township to be sold. Indian Township had been reserved by treaty to the Indians forever, and yet the state thought, well, we'll sell it now. And in 1860, they passed another law. Finally, in 1860, they began to do it. They had been threatening to do it, 1834, 1854. Comes 1860, and they do it. They sell a mile strip to a fellow who wanted to put a road across it, a mile-wide road. And they have continued ever since to eat away at the land which was reserved to the Indians in the treaty. This is nothing new. In 1887, the Indians petitioned the legislature. Louis Mitchell went down to the legislature and said, all our land has been taken. This has got to be remedied. We're asking the legislature to do something.
It's also true that although some of the land was alienated early, the consequences to the Indians were continued. They affected not only the original 18th century ancestors of the modern Indians, but also more recent generations which have suffered poverty and involuntary dependency as a result of the expropriation of land without consent and without compensation that took place in a much earlier period.
Well, these points are good. Certainly, you're in effect replying to the question by saying that the issue is not as old, that there have been a history of continuous injustices, and this certainly seems to be the case. I take it that Bill is also referring to the fact that even if the injuries do not continue, the burden of those injuries may continue long after a particular injury occurs. And that's, I think, a terribly important point, that damage to the sense of community, damage to the sense of self-image, etc., can be a continuous burden for people such as the Indians have to bear. On the other hand, I would like to, I think, hit the question from a somewhat different angle, because I think the question implies a perspective that has some merit, namely that age is a relevant problem here. There are about three, I think, different points I would want to make from that perspective. First is, of course, the problem not merely that it's old. Jim is perfectly correct. The fact that it's old is not, doesn't have anything to do with the validity. But the age confers other characteristics sometimes. For example, obscurity, lack of clear evidence, the fact that a treaty, for example, has been forgotten, or one has been recently found but another one has not been found. And at some later and subsequent age, it becomes very difficult to piece together exactly the kind of implications, understandings, assumptions that people had when they entered into whatever agreements they entered into in an early time. And sometimes, at least, with the passage of history, it's very difficult in 1977, for example, to recreate the historical conditions under which people did or did not enter into treaties roughly 200 years ago. So the first problem has to do, I think, with obscurity of evidence. And of course, given that fact, there's a strong procedural rule that one ought to abide by earlier decisions, because on the presumption that the earlier decisions were in fact aware of circumstances and conditions and agreements that later ages might not remember. So this is the one issue. A second issue involved in this age claim, I think, has to do with the problem of the kinds of claims that are involved and the change in the kind of claims over centuries, and then even more significantly, the conflict between alternative claims. In other words, it may in the course of time be such that contradictory claims are viewed as legitimate. And then you have the problem of how to relate these particular ones. One of the problems for me, for example, is in relating the notion of aboriginal claims, and what do we don't go back 200 years for that. We go back 5,000, 10,000 years for that. And then we relate that to later periods at which, let's say, Europeans came and they claimed conquest, in some sense, was at least a legitimate grounds for asserting a claim.
Yeah,
and then on that basis, payment later.
Yeah, but the Europeans never claimed that their conquest gave them the right to take the land unilaterally. Their conquest just gave them the right to negotiate for the land. And they didn't negotiate for this land in accordance with the law.
This claim was made by at least one governor of Massachusetts in the colonial period, I believe. Right, that conquest...
As to only a portion of Maine.
Yeah.
As to a portion of his Indian claims, and that's one of the issues that's still left in this case, whether they did, in fact, take a portion of the land by conquest, but they never claimed to take it all.
Right.
Wayne, do you have something to contribute to this question?
I guess I'm looking at it from a person that has grown up being on the other side from my three colleagues here by the nature of who I am. One of the things that, in response to Jim's initial statement, everybody in the general public today seems to think, why the old claims? And that has been asked me. And the thing that I thought of the most was, I'm 35 years old. And in my own lifetime, I've seen at least two major things taken from us in terms of land. One of them was a situation at Indian Township where the United States government needed a camp or a prison for German prisoners during the Second World War. So they picked Indian Township and took that land through various methods. After that land was not used anymore, after we won the war, it was then turned over to the state and then sold to non-Indians. So there's a big parcel of land right now in the middle of the reservation. And the other thing is building of railroads and roads on the reservation. A road was built in the early 60s, and we were never compensated, even in the normal manner of when eminent domain is used. So these are the things that are happening today that concern me very much. And as I hear the conquest of 200 years ago, or the theoretical conquest, I think back on the Second World War, and I was talking to a gentleman from Japan the other day, and I said, it's really amazing. I said, even after we defeated Japan, we gave them back their land, we gave them back their pride. And so that's where I'm coming from in this, that it isn't something old, it's something happening today in this country. And the thing that makes it rather obscure is the fact that the American public just does not know about it. The American public, in a lot of ways, just doesn't respond to this kind of thing because Indians no longer are a military threat. So they somehow let loose on their own guidelines of justice when it comes to Indians and Aboriginal title.
You know, I think Wayne's being kind by saying that the last time he can remember was 1960. I remember 1975 when the State Forestry Department had a building they had built on Indian land with nobody's permission. The Indians said, well, you built this with nobody's permission, and it really is our building. And the Forestry Department and the governor said, no, it's not. You're not going to get it back.
Obviously, we could go on.
There was another
Okay.
case in 1966. But
Okay.
Could I though pick up one aspect of this question?
Very brief, because we have a few others we'd like to
When
say.
people speak about the oldness of the claims here, I think perhaps primarily what they have in mind is something of the following sort. Suppose a set of agreements, treaties, maybe they were not fairly entered into, but a group of them arise around the 1790s. And suppose in 1977 or 1975, we say that was mistaken. That is to say the Treaty of 1794 was a mistake. It was incorrectly done. I think at this point, the question of how does one rectify such a mistake is a very serious question. I think one of the major things that has changed, for example, and that one means by the oldness of the claim, is that the significance of a particular injury is different now than it was then. The whole impact of population, the whole procedure of developing agricultural society and industrial society, the mere science of population makes the significance of that act very different now than it was then. Therefore, what I'm trying to say is, to simply reinstitute the status quo of 1794, for example, I don't think follows from a recognition that an injury might have been done at that point.
I think I have one little reaction to that, and that is, I think if I understand your statement, I think a settlement can be reached in 1977 that is acceptable to the Indian people. I think that when you bear in mind the kinds of things that we're pursuing, the Indian people have been very willing to sit down to talk of a mutually acceptable settlement, not something arbitrary on the part of the mighty hand of Congress or the mighty hand of the President. But keep in mind our victories in the court. This is a system that was established not by the Indians, but by the dominant society. We use that system effectively and with good grounds, and that system, the legal judicial system of this country, continues to back us. And to have the case settled on political expediency is wrong.
Right, and no statute of limitations applies either to the Indian land claims or to the damage claims based on the land claims.
I knew the first question was going to be a long one, but I didn't think quite this long. Can we go on to the next one? And maybe if we have time at the end, we can come back to number one again.
More.
What is the case doing to the economy of the state during the transition, before a negotiated or court settlement? What will happen if they win? We hear this over and over, this concern. Who would like to start on that one?
I think we need to recognize that those are two very different questions. You know, what's happening now and what will happen if they win. They, in this case, of course, being the Indians, but they, in this case, I think, being we. If the Indians win and get 25 million or 100 million or however many millions of dollars, it'll be one of the largest imports of capital this state's seen in a long time. It certainly can't hurt the economy to have a great deal of money around, managed by people who are going to live here. That's a fairly simple problem. If they win, we all win, because we get more money, more jobs, all that. The question is what's going on now and what will happen in the interim. And no one can really give a good economic answer to that. We know that some towns last year had a difficulty selling bonds. That seems to have phased out. I don't want to say it's gone away. It's phased out for the time being. We really don't know.
I think a large part of that, Jim, has been backed up by the tribe's own action to say certain things. For example, the tribe has said it will not evict anybody. It will not go for landowners, small landowners. It has made clear statements that it is also interested in seeking justice to those non-Indians. And I think behind all of the rhetoric, if people take an objective look at the actions of the tribe to alleviate any kind of economic disaster, we should be looking pretty well, because I think that we have gone out of our way to seek an out-of-court negotiated settlement so that the economy of the state will not be disrupted. Because you see, when you shut down hospital financing, when you shut down other financing, the Indians are also victims of this. And sometimes people forget that, I think.
I think this point that has just been made, coupled with Wayne's earlier point about procedural entering into the legal system, is very reassuring and very important. On the other hand, at this point at least, The question is whether that kind of a verbal reassurance is sufficient to alleviate fears with respect to what might be the economic consequences, I think can still be significant. And that is, to me, where the trouble may lie. I think Jim is correct that the weight of the question lies not after a settlement is made, but rather in the transitional period before that settlement is made. And the issue, of course, the scenario that one can easily develop, despite assurances, let's say the private landowners won't be evicted, is that you have a cloud title to the land. Therefore, you don't know precisely how to proceed with it. From the point of view of banks, why should they give a loan, for example? Why should they extend a mortgage if in fact, the title is clouded? Why should somebody construct a building, for example? And then that slows down the economy.
You had the same kind of a problem in Mashpee, Massachusetts, and the banks just sort of withdrew and said they weren't going to give any more mortgages in this disputed area. But that was quite different because there, the banks were all around Mashpee and there was just a little place. Here, the banks are right in the middle and they're swallowed up by the claim. If they stop giving mortgages on the land, they'd go out of business. So the banks really can't just pull out and say we're not going to have anything to do with it. But you do have some very severe technical, legal problems. Wayne is correct that the tribes have consistently asked for negotiation. They've consistently said they're not going to evict small landowners. But technically, as he knows, and as his attorneys know, if they have to sue, they will have to put a legal cloud on the title of all of this property. And that's one of the reasons they apparently don't want to do that. They don't want to put this cloud on the title, but if the state gives them no choice but to sue, there probably will be some more disruptions, and that's just one of the natural consequences of litigation.
Are you saying, Jim, that they have to sue for everything that they could claim in order for their suit to be valid?
That's the current understanding of the law. There was another case in New York with the Oneida Indians where they apparently didn't sue for all of their Aboriginal territory, and this made the claim, it didn't make it invalid necessarily, but it caused them to go out of court and start over again. And we understand that if the Indians have to bring this claim, they have to bring it for everything.
Okay. Well, I think at least we are all in agreement that the big danger is not what happens if they win, but what happens before some settlement or some resolution to the problem is made. And even Governor Longley, I think, has indicated that his great fear is what happens in the interim. And that's why I am puzzled that he doesn't jump at the chance to make a settlement, which is backed by President Carter and by his representative, Judge Gunder, and which offers millions of dollars coming into the state, and particularly into the depressed eastern and northern counties, and offers the added incentive, it seems to me, of converting some people who are on welfare in Maine into entrepreneurs and prospective employers who can contribute to the economy of the state.
I think you got to bear in mind, Bill, one thing. That is, the politicians of this state, including the congressional delegation, have heard of this case since before 1972. It wasn't until a few banks decided not to finance some projects that they began taking it seriously, I believe in 1975, early 1976. It wasn't until then that this state really took it seriously. Everybody, I think we grew up with a lot of jokes about, when are you guys going to win? You know, we don't hear too many nowadays because people are taking it seriously. And so unfortunately, it's taken our politicians this amount of time to even begin to understand the real implications. This is not just a political football that can be bounced around. It's a very serious matter.
I think this is one of the interesting, important things, that it is a serious issue and is regarded as a serious issue, and certainly that's a major step forward. Don't you think we could all agree, or very likely agree, that in fact a negotiated settlement would likely be the best procedure to follow on grounds that if that were to occur, all parties would in effect be willing to say at the end of it, we agree to this solution. Therefore, it would limit the amount of time, and if the negotiation were speedy, then the combination of negotiation over litigation and of speediness versus slowness would be such as to keep the economic disruption, the potential economic disruption, to a minimum.
A negotiated procedure would be a less painful procedure. I don't think there's any question about that.
The next question that we had has really already been answered, but I'm going to read it because it's something that is very current and constant in the minds of people. How can Indians who have bought and inherited land, paid taxes, improved it, and who love the land be evicted from it?
You don't mean Indians, you mean
I'm sorry,
non-Indians.
non-Indians.
Of course, it might be applied to Indians also.
It could, possibly.
Thank you.
But
Wayne has answered that.
There are probably a number of people in the state of Maine who are legally Indians who might be evicted by this claim, but that's another.
That's unusual.
But I think there is a concern here. I'm in this position. People in Bangor, non-Indians, could be in this position. We bought land in the Passamaquoddy claim area, for example, 5 or 6 years ago. Now, what does that, we took some small inheritance, we put a mortgage on some property elsewhere in order to buy that land. Naturally, we fear, even if we have verbal assurances, that nothing would be done to it. We fear that it would be taken. And there's a sense then, suppose, on the one hand, I agree, Indians have been badly treated in the United States, and continuously so, not merely early in the history. On the other hand, in order to rectify those, you've got to be very careful that you don't injure somebody else. So it's a problem of fairness here is, I think, one of the central problems.
Well, there's no question now that if land is taken, somebody will pay. The somebody, in this case, is probably the federal government, because let's not forget what the 1974 and 75 decisions said. Those decisions said that the federal government had a trust relationship with the Indians and was required by law to watch out for their land transactions. The federal government, if anybody, has violated that trust relationship, its duty as a trustee, and they would be paying. So, we're not talking about throwing people off their land with a carpetbag. We're talking about, at the very worst, paying them fair market value for that land.
I think this is an important principle, and it's the principle that if an injury were done, and we can establish, perhaps through legal or negotiating procedures, what the extent of the injury was, then the question of how to rectify it and how to distribute the burden of that rectification becomes important. And fairness, I think, would have to say that individual, for the moment, private people, would need to be reassured that they would, in some sense, be compensated. There is, of course, a problem of positional goods, what the economists call positional goods, that cannot be shared. But those can, to some extent, be translated into a financial burden, which can be shared. And I think that's the important point, that if the mistake has been made, it was not made by me or other living Americans against other living Indians, but rather by our forefathers. And that, therefore, in some sense...
But it has been...
Yeah, I disagree with that,
Yeah.
because it was
Okay,
made
aside
against
from the
me.
continuous injuries.
Yes.
You're correct on
Not
that.
only that, but we benefit from it.
That's correct,
Look,
too.
in 1887, when Louis Mitchell addressed the legislature, he said, just consider today how many rich men there are in Calais, St. Stephen, Milltown, Machias, East Machias, Columbia, Cherryfield. We see a good many of them worth thousands and even millions of dollars, he said. We ask ourselves how they make their money. The answer is they make it on lumber and timber once owned by the Passamaquoddy. And we didn't just take some land, we took a way of life.
No, this is absolutely correct.
Let's go on to the next question. If the Indians win in Maine, won't there be lawsuits throughout the country? Isn't this just the tip of the iceberg?
I'm not sure of the pending cases right now, but I believe most of the cases that are going to be filed have already been filed. I think this is a scare tactic on the part of our opposition of the dooming fear or whatever is coming down the pike. I think that if there are legitimate claims, the American system says they are to be redressed in the court. So even if there are, we have to deal with the issue. And you can't, again, you can't deal with it by a congressional blessing of any kind. You must deal with it because each individual party has a specific grievance. So, if there is, I think this court, if this judicial system is strong enough, I think it can deal with it effectively.